Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Lebenz. On today's video, we are going to talk about what happens when one party fails to disclose evidence. What are the procedures and what are the potential remedies? So let's start with this question of what qualifies as a failure to disclose. This is going to be under Rule 49, and it explains that a party prejudiced by a failure to disclose, false or misleading disclosure, or untimely disclosure may seek remedies in Rule 65. So just because a party doesn't produce something doesn't necessarily mean that it's a problem. It's a problem if it creates prejudice. Also, if somebody engages in disclosure, but that disclosure is false or misleading, that's a problem. And then if the disclosure is untimely, that can also be a failure to disclose. There's additional rules related to electronic information. So parties have a duty to preserve electronic information. And if you're anticipating litigation, you're already aware of it, then you're supposed to take reasonable steps to preserve that electronically stored information. And if you don't do that, then the court can sanction you for it. Now let's look at a motion to compel. So if there's been a failure to disclose, then your remedy would be to seek a motion to compel. So a party may move for an order compelling disclosure or discovery. The party must serve the motion on all other parties and affected persons and must attach a good faith consultation certificate complying with Rule 9C. There's several types of motions to compel. You can have a motion to compel disclosure. If you're alleging that the other side has failed to disclose information required by Rule 49, then you can file a motion to compel disclosure and seek appropriate sanctions. If you've served the other side with a discovery request and they didn't respond, either they didn't respond at all, they didn't respond in full, or they provided false or misleading responses, then you can file a motion for an order compelling an answer, designation, production, or inspection if any person or entity has not complied with the discovery rule. And then under C, if there's been a deposition and someone refuses to answer a question, there could be a motion to compel for them to answer the deposition question. But for today's video, I'm really going to focus on a motion to compel disclosure or a motion to compel discovery, because those will be the most common types of failure to disclose motions. If you are the party being accused of withholding information or of not disclosing, then the motion would be filed against you and you would respond to it. But here we're just talking about a motion to compel disclosure or a motion to compel discovery. And I'll give you an example of what that looks like later on in the slides. Now, if the motion to compel is granted, or if you file it and after you file it, the other side produces the disclosure or discovery that has been, that they've concealed up until that point. In that case, if the motion is granted or if the paperwork's produced after filing, then after giving the other side an opportunity to be heard, the court can require the party or person whose conduct necessitated the motion to compel to pay the movement's reasonable expenses incurred in making the motion, including attorney's fees. The court may not order this payment if the movement filed the motion before attempting in good faith to obtain the disclosure or discovery without court action. So before you run to the court and file a motion to compel, you first need to try to resolve the disclosure dispute between you and the other side, either your opposing party or their attorney, if they're represented by an attorney. So you need to attempt in good faith to obtain the disclosure or discovery without court action. If the opposing party is not disclosing or not responding or objecting and they're doing so in good faith, then the court can't order them to pay your expenses. or if other circumstances make the award of paying your fees and costs unjust, the court can't do it. So if there's been a failure to disclose, one of the remedies can be a payment of the other side's fees and costs for bringing the motion to compel, but there are some exceptions for good faith, a failure to attempt to resolve the matter, or if it would just be unjust. Now, if you file a motion to compel and you lose on the motion, it's denied, then you get an opportunity to be heard, but you could be ordered to pay the other side's expenses if you lose. If your motion to compel is granted in part and then denied in part, then the court, after giving each side an opportunity to be heard, could apportion expenses, including reasonable fees between the parties. Bottom line is you want to make sure you have a good case before you file a motion to compel, because you could be ordered to pay the other side's fees and costs if your case is not strong. All right, let's look at what are some of the remedies you can request if you can prove a failure to disclose. First, we've got for not obeying a discovery order or rule. If a person fails to obey an order to provide or permit discovery, or fails to comply with a disclosure or discovery rule, the court may enter sanctions, including but not limited to the following. The court can direct that designated facts be taken as established for purposes of the action. So let's say that there's a particular bank account that one side's hiding, and it's never produced for some reason. I mean, you could get a subpoena, so this isn't the best example, but I'm going to go with it for now. If there's something that the court orders to be produced and it isn't, the court could direct designated facts be taken as established. So in this bank account example, the court could direct that it be found that this bank account exists, even though we don't have any records of it, and that it has a certain value. There could be designated facts established, even though the records were never produced. The court could prohibit the disobedient party from supporting or opposing designated arguments or from introducing designated matters in evidence. So they could be prohibited from presenting an argument because they failed to disclose certain information. The court can strike pleadings in whole or part. The court can stay further proceedings until the order to compel or produce is obeyed. The court can dismiss an action or proceeding in whole and part unless dismissal would be contrary to the best interest of the child. The court can enter a default judgment in whole or part against the disobedient party, or the court can schedule a proceeding to treat the violation as a contempt of court. So you have a question, what is the difference between a motion to produce and a motion to failure to disclose? So it's called a motion to compel, and it's to compel the production of disclosure or discovery. So it's just one type of motion, and it's a motion to compel the other side to comply with the rules. And then these are the remedies that you can request. An additional remedy you can request is payment of fees and costs that you incurred seeking to get compliance with the rules of disclosure or discovery. Now, if the issue is the failure to preserve electronic information, there's additional remedies for that. The court can order additional discovery to restore or replace the electronic information. However, if the electronic information simply cannot be restored or replaced through additional discovery, then if the court finds prejudice to the other party from the loss of the information, the court can order measures no greater than necessary to cure the prejudice. Or if the court finds that the party acted with the intent to deprive another party of the information's use in the litigation, the court can presume that the lost information was unfavorable, or dismiss the action or enter a default judgment if there's prejudice. So there are additional specific potential remedies if a party has failed to preserve electronic information. What if you miss a disclosure deadline? In that case, the court can order that you can't use the documents. So a party seeking to use information, a witness, or a document that it first disclosed later than the deadline set in a scheduling order or a case management order, or in the absence of such deadline, less than 30 days before trial, must obtain leave of court by motion. The motion must be supported by affidavit and must show that the party acted with due diligence, could not have earlier discovered and disclosed the information, witness, or document, and the party disclosed the information, witness, or document as soon as practicable after its discovery. So if you are disclosing something and there's less than 30 days before trial, or it's after the deadline set by the court, it needs to be something new. And you're going to need to file a motion with the court, asking the court to allow you to use it and explaining why you haven't disclosed it before this time. All right, let's look at an example of a motion to compel. Now, Maricopa County did not have any set forms for this, so I created one. And what we've got here is the caption, so you'd fill this out. Of course, list the name of your county. And then marriage or matter, this is going to depend on what type of case you have. If you have a divorce case, then you're in re the marriage of. If you have a custody case or you're post-divorce or post-custody establishment, then you're in re the matter of. Put the name of each party, your case number, and then what are you looking to compel? Is this a disclosure violation? Is it a discovery violation? Is it both? Tailor this to your case. So if you're the petitioner or the respondent, indicate which party you are, and then indicate what you're pursuing. Is it outstanding disclosure or outstanding discovery? Date and sign. Let's go to page 2. So here's your memorandum of points and authorities. This is where you're going to lay out the facts leading up to you filing this motion. So if you're looking to compel disclosure, indicate when disclosure was due. That's what these first 2 paragraphs are about. Number 3, indicate what's missing from the other side's disclosure. Specify that out. You can have as many sub-paragraphs here as you need. Paragraph 4, indicate when you reached out to the other side to try to resolve this. Maybe you started with a letter or an email. Attach a copy of your letter or email. And then did you have your good faith consultation call? The date you had the call, how you tried to resolve things. But despite all your efforts, as of the filing of this motion, the opposing party has not produced the missing disclosure named in paragraph 3. Now, let's say they produced some stuff after you sent the letter and had the call. Tailor this paragraph to indicate what has been produced, but what is still outstanding. Also, if you didn't use paragraph 1 and 2 and this number for paragraph 3 changes, you're going to need to update the number here so that you're referring to the correct paragraph. All right, so you can see the parts I put in red are what you really need to edit, but you're going to need to read through your document and tailor it accordingly. If you were looking to compel discovery, then you would include these allegations. If you have a discovery and a disclosure issue, you could include both. So regarding discovery, on such date, I served the other party with my discovery request. So you'll need to pick out what type of discovery request you used, when their responses were due, that the deadline passed and they didn't respond, the efforts you made to try to resolve this in writing, the phone call you had, the information about that, and then as of the filing of this motion, it's not resolved, something to that effect. This part right here is standard parts about the law. You can just leave these parts as they are, and of course you can read them to gather more information. So if I go back, this part is about the motions that are available. This part is about that good faith consultation that's required. And then this is about the failure to disclose, like what are the remedies if there's been a failure. And then we get into the law and argument. So again, you're going to need to tailor this part to your case. But I have the number 1 argument, the opposing party failed to complete disclosure discovery, and then explain what the violation is in this paragraph. Explain your good fault. Then here's where you can do your good faith consultation certificate. Pursuant to Rule 9C, I made a good faith effort to consult in an effort to resolve the disclosure/discovery dispute. So explain that. and then indicate what you did. So tailor this to your case. And then here, your requested remedy. What do you want the court to do about the alleged violations? And then here's your conclusion. You're asking the court to find the opposing party failed to complete disclosure or discovery. Tailor this to your case. Find that you consulted with the opposing party or their counsel. Tailor this to whatever you did in good faith, pursuant to the rule. Grant your motion to compel. Order, this will be the other side. Indicate what the party the other side is. Explain what your requested remedy is. Award you your reasonable legal fees and costs. Any other orders you want, list those here. If you're not asking for anything else, you can take that out. And then finally, any other relief the court finds just in the circumstances. Date, sign, complete your mailing certificate, and then you file this with the court and mail it to the other side. Upon you filing and mailing, which is serving the document, the other side gets to do a response. They have 10 business days plus 5 straight days. That'll be their deadline to file a response. So let's look at the response. On this side here on the left, I've got the motion to compel that we just looked at. And then here on the right, I've got the response to motion to compel. And anytime you do a response, it's going to be responding to each paragraph in the motion. So fill out your caption accordingly, fill out this opening paragraph correctly, and then we're going to be getting in to the motion. So here we've got paragraphs 1 through 6. So here, this is where you want to admit or deny each paragraph. So you'd read paragraph 1. If you agree with what's in paragraph 1, you would admit it. If paragraph 1 is not accurate, you would deny it and then explain what you're denying. Explain why you disagreed with the paragraph. And you want to do that with each paragraph. Anything not specifically admitted is denied. That's an additional allegation to make in a response. And then for the motion to compel discovery, again, admit or deny. So tailor this, but I'm trying, it's tough to make a response template because I don't know exactly what the other side's motion is going to look like. But the bottom line is you want to go through each paragraph of the motion and explain your position on it. Do you agree or disagree with what they're alleging? The law, if you have anything else about the law, you can put it in here. But for the most part, the law is what the law is. So that'll be all set. And then we get into law and argument. So in the motion, they're saying the opposing party failed to complete, disclosure. And here you can say, I did not fail to complete disclosure, if that's your position and if that's true. But in this first paragraph, you want to explain why the allegations do not amount to a violation and explain why you were in compliance from your point of view, if that's your position. Then there's this paragraph about the good faith consultation certificate. So here in the response, they're responding saying, no, the opposing party did not consult in good faith, and explain what their obligation was and how they didn't abide by that. And then here they have their requested remedy. So here I object to the requested remedy and explaining why. So this part of law and argument, of course, you're going to need to see what's in the motion you're responding to, but each argument in the law and argument part of the motion is what you're wanting to do a response to in your response. That matches up with your position. So then we get to the conclusion. You're asking, if you're doing the response and you're objecting to the motion to compel, then you're asking the court to find that you did not fail to complete disclosure or discovery, find the opposing party or counsel did not consult in good faith, deny the motion to compel, deny the requested remedies, deny the request for fees and costs, award me my reasonable legal fees and costs, other orders, state any other orders you're requesting, and any other relief the court finds just in the circumstances. So complete your mailing certificate, file it with the court before the deadline, mail a copy to the other side. Upon you mailing a copy to the other side and them receiving it, they then get to do a reply. They have 5 business days plus 5 straight days as their deadline for the reply. So here's an example of a reply. So we've got the response on this side, here's the reply, and the reply is replying to what's in the response. So paragraph 1, again, we're still tracking paragraph 1. And if this paragraph was admitted in the response, then you can write that paragraph 1 is not in dispute. So if both sides agree that paragraph 1 is correct, then paragraph 1 is not in dispute, and you could write that. Alternatively, if paragraph 1 was denied in the response, then you can reply to that denial and otherwise explain your position on their denial of that paragraph. And you'll want to do that for each paragraph in the factual allegations. If there's anything else about the law, you can put that in. And then we get into the law and argument. So in the motion, we're saying the other side failed to complete disclosure or discovery. In the response, they're saying, no, I didn't, I'm in compliance. And now in the reply, you're saying, no, they did fail. And you'll be replying to what's in the response. So whatever reasons they're giving for why they're in compliance, you would look to address those in your reply. And then if there's an issue about the good faith consultation, that can be addressed in your second paragraph. And then arguments about requested remedies could be in the third paragraph. And then you've got your conclusion here. You're asking the court to find the other side failed to complete disclosure or discovery. You want the court to find you consulted in good faith. You want the court to grant your motion. You want the court to order, whatever your requested remedy is, explain that there, award your fees and costs. And then any other orders that you want the court to order, you can explain that there. If you don't have any other orders, you can take that out. Finish your mailing certificate, sign, and then that's when you file this with the court and mail it to the other side. And at that point, this issue is what we call briefed. All of the pleadings related to this motion to compel are now done. At this point, the court could set an oral argument or an evidentiary hearing in order to resolve the motion to compel. All right, so let's look at what happens if the motion to compel is granted. So if the motion to compel is granted, then if the motion is granted or if the disclosure or requested discovery is provided after the motion was filed, then the court has to give both sides an opportunity to be heard, but then can require the party or person whose conduct necessitated the motion to pay reasonable expenses of the moving party, unless there was no good faith attempt to resolve it prior to filing the motion, or the opposing party's objection or non-disclosure was in good faith, or other circumstances make an award of expenses unjust. Now, what if the motion to compel is denied? Then you could get ordered to pay the other side's expenses. If it's granted in part or denied in part, the judge can make a decision about whether or not there should be any payment of expenses by either side. All right, we've come to the summary now. So just with a failure to disclose, it could be a failure to disclose under Rule 49 of the required disclosure rule. You could have a failure to respond to a discovery request. A discovery request are interrogatories, requests for production, requests for admissions, a deposition, things like that. You could fail to answer questions in a deposition, or if you provide evasive, incomplete, non-responsive answers, that all fits within failure to disclose. Also, untimely disclosure fits as well. So if you're going to pursue a failure to disclose, it starts by filing a motion to compel, where you need to explain the violations, explain your requested relief, and explain the good faith efforts you made to resolve it. In the response to motion to compel, explain the alleged violations from your perspective, explain what happened or didn't happen with the good faith consultation, explain your position on the requested relief, and then in the reply, you're going to reply to the arguments in the response. And then when ready, the court will rule on the motion to compel. All right, thank you so much for joining me today. I hope that was helpful.